Hi, I'm David Cantor with the law offices of David Michael Cantor, and today I'm going to talk about aggravated DUI, which is a felony DUI, and statute of limitations. People often ask, well, how long can they charge me with a felony DUI after I've been stopped? They have up to 7 years to charge you. Now what happens is a lot of times they draw your blood, you'll be taken to jail, you'll see a judge and they'll set the case to what's known as a preliminary hearing. It's quite common once you hire us, especially, where we file our notice of appearance and the prosecutor says, wait a second, I don't have all my ducks in a row, I don't have the blood results yet, and they scratch the charges. Now that doesn't mean, wow, you guys are the greatest, you got the case dismissed, it's gone forever. It just means once they get those results, it can be reactivated. Now they have up to 7 total years to charge you with the felony DUI. What we do once a case is scratched is we monitor everything by doing warrant checks every month for approximately 3 years. And if you haven't been charged after 3 years, it's possible they won't charge you. Now, here's where it gets tricky. If you lived in one location and you moved and they send a summons to your address, let's say a year after you were stopped, and you no longer live there, they will not forward a summons. So that means a warrant for your arrest will go out. And it's quite possible that years later you're driving along on the road, you get pulled over and they arrest you for a warrant on felony DUI. And that can be bad. This usually happens with people who live in apartments or people who are moving addresses due to work. Now the DMV is a separate issue. Now in the DMV, if your blood comes back above an 08, they'll send you a notice in the mail saying they want to set a hearing. And many people say, well, wait a second, am I charged, am I not charged? Well, it's completely separate. You have to deal with the DMV, and if they find that you're above an 08, they'll suspend you for 90 days. You also have to deal with the criminal courts. Now the reason we like to be involved in cases, even if they're not charged yet, is when we go to the DMV, we interview the officer and we lock them in under oath on tape, and we can use that information to contact the prosecutor later and convince them that they should never file charges against you. We call this the pre-charge or the investigation case stage of a case. Now if you go to our victories site, you'll see a lot of victories we have on aggravated DUIs where we win them outright, and also in the pre-charge phase where we keep them from ever being charged, where they've been scratched, and then we convince the prosecutor, don't bring this case back up. But if you have a potential DUI or aggravated DUI, contact our office. We have a 24-hour answering service, and they can get you to a lawyer to talk to you. Also, you can set for a free initial consultation that won't cost you anything, or you can go to our website, dmcantor.com.